Good morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
She had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds, ma'am. You're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that a standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
After finding probable cause for the DWI charge, Judge Fleischer placed so-called conditions on Ms. Hawkins' bond, ordering her not to consume any alcohol and not to drive at all, despite the fact that the prosecution, in a written motion, had only requested that Ms. Hawkins be required to install an ignition interlock device, or IID, which is a breathalyzer installed in a vehicle that prevents it from starting if alcohol is detected in the driver's breath. Under Article 17.441 of the Texas Code of Criminal Procedure, judges must require defendants charged with repeat DWIs or aggravated offenses, such as DWI with a child passenger, to install an IID as a condition of release. Now, because Ms. Hawkins was a first-time DWI defendant, Article 17.441 did not mandate an IID in her case. However, under Article 17.40 of the Code of Criminal Procedure, judges have broad discretion to impose, quote-unquote, any reasonable condition of bond related to the safety of the community. Now, while judges cannot use bond conditions as a form of punishment before a conviction, as the 14th District Court of Appeals in Houston explained in the 2022 case of Ex parte Bucks, appellate courts review challenges to bond conditions under a so-called abuse of discretion standard. This means that a trial court's decision will not be overturned so long as it falls within the quote-unquote zone of reasonable disagreement. Well, here, given the allegations that Ms. Hawkins was driving while intoxicated and had an open container of alcohol in her vehicle, it is highly likely that a reviewing court would conclude that Judge Fleischer's restrictions prohibiting her from drinking alcohol and from driving a vehicle were reasonably related to community safety, and therefore not an abuse of his discretion.
Understood.
We can approach at a later date, but I'm
concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting an interlock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, be proactive. It's not forever, Aaron, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously. I don't want you to talk here now in front of him. You guys at a later date can come back. I'm always all ears. It's not
For
absolute.
Greg's purposes, since he's going to be the one representing her, well, what is a later date? I mean, is there something we can do? Because, if it's something that you'd like her to do while on bond to make sure that she's, addressing the issue, I mean.
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, but it's something that I've seen more and more, where there's alcohol in the car, and I would presume that you would know, especially at this age that,
Well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the dim summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit.
Mr.